That'd be really. All right. Again, thank you everyone for being here today. My name is Raylene. Like I said, I am one of the advocates here at Standpoint. I will be helping to facilitate the webinar and I'll be chatting with you all a little bit later on. As mentioned, the webinar is being recorded and you will be able to check this out on Standpoint's YouTube page in a few days. The link to the recording will also be emailed out to Standpoint's Legal Advocates listserv. We will get the PowerPoint sent out to you as well, so you'll have that to follow along with. If you have questions during the presentation, please type your question in the chat box, and we will get to all the questions at the end of the presentation. Most of you probably already know about Standpoint, but for those that listen to this later and for those that don't know, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings like the webinar today and answering calls to our action line. Examples of trainings that we do are the annual New Laws training throughout the state of Minnesota, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. It is through this action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety planning, listening, and helping callers identify possible options and next steps. Today, we will be talking about Confidentiality 101. So Tori's going to get us started with that. But before we jump into that, Tori joined Standpoint in August of 2024. She is a graduate of New York University School of Law. Throughout her career, she has advised businesses and nonprofits on a variety of issues, including their confidentiality obligations under federal, state, and local laws, performed investigative work, and represented clients in litigation. She has also done pro bono work for and volunteered with organizations such as the Legal Aid Society and Covenant House, New York, aiding clients with VAWA petitions, applications to obtain benefits, and housing court cases. As a staff attorney with Standpoint, she works with multidisciplinary teams to provide training on maintaining confidentiality under the Minnesota Safe Harbor Law. And then I myself am the housing and supervising advocate here with Standpoint. I began as an advocate in 2009, focusing on housing stabilization, crisis intervention, shelter work, hospital-based advocacy, program development, and volunteer management. And with that, what I will do is get the link to Dropbox so you can follow along with the PowerPoint if you would like. And I'm going to turn it over to Tori to get us started.
Thank you, Raylene. So today we're going to talk about confidentiality, which feeds into privacy and privilege. And the reason why we talk about this is because it's very important. It helps basically everyone be comfortable in understanding their role, what information can be shared, when information is protected. And most of all, it helps victim survivors or clients understand what their rights are and be able to make informed decisions about what information to share and when to not share. Hope the PowerPoint is working. There we go. So privacy, confidentiality, and privilege, what do they mean? Privacy is a personal choice whether to disclose information. So that's going to be our clients making that choice about what they want to share and when they want to share it. Confidentiality is a responsibility to protect someone else's choice about disclosure. And that's going to be an obligation for us as the professionals who work with our clients. And privilege is a legal rule that prohibits the disclosure of private information against someone's will. And there are many different types of privilege. And basically, what they say is there's an understanding in the law that this client professional relationship is important and the information that's shared should be protected and should have some extra scrutiny before it can be shared. And, as we said, it's very important because once we understand what our obligations are, what the rules are, it helps us feel more confident and be able to serve our clients better with problem solving, safety planning, anything that comes up. And it also helps our clients feel more comfortable reaching out for help or reaching out to your program, advocating for themselves. So these are very important concepts to always keep in mind as you're working day to day. Where do confidentiality requirements come from? They're going to come from federal laws, state laws, contracts, and your program's own policy is going to have generally some form of requirement that you keep certain information confidential. The federal laws here are going to be FIPSA, VOCA, and HUD. And the way how this works is if you received any sort of funding that flows from one of these sources, whether it's a grantee, sub-grantee, whatever it is, these sources are going to impose confidentiality requirements on your program, on your staff. And some of it's going to be very particular about what information is protected. For example, VAWA protects personally identifying information. It requires you to keep that information confidential. And that's going to be information likely to disclose the identity or location of a victim, survivor. Um, and it's going to be anything from name, address, contact information, social security number, date of birth, racial, ethnic, or religious identity or affiliation, and any other information that could identify an individual. And that's very important because depending on your community, depending on the specific client, something that you may think is a mundane fact could actually serve um, to allow someone else to figure out who you're talking about and that that person has either sought, utilized, or were denied services from your program. And it is important to note that this confidentiality applies to everyone who seeks out your program if you receive any funding that comes from VAWA. And it doesn't matter if they actually use your services or if they're denied um, or anything like that. You are going to be required to keep that information confidential. Some state laws that come into effect impose confidentiality requirements are going to be the Minnesota Government Data Practices Act and also the privileges for sexual assault counselors and domestic abuse advocates. And you'll see here I've listed the statutes that define certain types of data under the Data Practices Act. And we'll talk a little bit more in detail about that next as we talk about the Data Practices Act. So what this does is it classifies data in a certain way, and based on that classification, access to that data is restricted. It applies to all information in any form, doesn't matter, email, text, whatever it is, microfilm that's collected, created, received, maintained, or disseminated by any government entity. The broad categories that they use are public data and non-public data. The default for data under this law is public. So information is considered accessible to the public unless it's further classified under the Act as one of the non-public data options. So that's going to be private, confidential, non-public, or protected non-public. Here's a chart from the Minnesota House Research Department that shows you the various categories and who can access which category of data. So when it comes to private data, which is what I'm going to talk about for the most part today, um, that's going to be data about an individual, and it can only be accessed by that individual or with their consent. And you also want to note here that that data is private data for up to 10 years after the the subject of the data, the victim survivor, has passed, or 30 years after its creation. So who does it apply to? Why are we talking about this, right? It's about government entities. So it's going to apply to state agencies, political subdivisions, statewide systems, corporations, nonprofit social service agencies under contract with a government entity, which is generally going to be domestic and sexual violence agencies. So that's where this comes into play for us. How is that data categorized? Well, domestic violence data, sexual assault data, and general crime victim data is considered private. So data that can only be accessed by the person the data is about or with their consent. And one thing to note here is that it is important to understand the specific definition they're using when they're talking about this data. For example, when it comes to sexual assault communication data, pretty much anything that's shared is going to be covered. But when it comes to domestic violence data, what's protected there is going to be personal history information or other information that can lead to identifying a client or figuring out their location. And as we talked about with the VAWA definition of personally identifying information, that was also based on identity and location. And there are a number of factors, or there are a number of categories of information that could potentially lead to identifying a person or their location, religious affiliation, um, you know, their actual contact information, their anything that leads someone to figure out who you're talking about, especially depending on the community you're in, um, or whether or not or where they are, whether or not they're at your shelter or things like that are going to fall into this category. Um, but some categories are broader than others. So you do want to have some understanding of what definition the law is using. Are parenting time centers covered? Um, that's going to depend on if they receive funding from any of those sources that impose confidentiality obligations. So, we have some federal ones listed, but also if there's any state funding that has any obligations for you, then that's also going to provide some coverage. Otherwise, you can kind of do a client by client analysis depending on the facts on hand. So, for example, if your client is the victim of a crime, if you receive funding from OJP, then their identity and location data is considered private. And I was just talking about the importance of definitions here. A crime is defined as conduct that's prohibited by the law, for which someone can be sentenced to imprisonment with or without a fine. So that's not going to cover everything that is, um, you know, but so it's important to know what definition the law is using when they're using words that we might commonly use in a different way. Statutory privilege. There is no statutory privilege in Minnesota for parenting time centers. I just want to highlight that. So that's why sort of the avenues for protection there are really going to be any funding source obligation or the Data Practices Act through that analysis. So for statutory privilege, we're talking about the sexual assault counselor privilege and the domestic violence advocate privilege. So here's the sexual assault counselor privilege definition from the statute. It's going to be a person who's done the 40-hour training, works under the direction of a supervisor in a crisis center, and whose primary purpose is to render advice, counseling, or assistance to victims of sexual assault. And I've kind of broken the definition down here because as it's written, it's not necessarily straightforward. For example, what constitutes primary purpose? Is it if more than 50% of your work is rendering advice, counseling, or assistance to victim survivors. So if you have a question about whether or not you fit into this definition, that's something that you can talk to an attorney about your program, about your role, about your clients, to just get any comfort on where you fall in that scheme if you have any questions. And then the statute says sexual assault counselors may not be allowed to disclose any opinion or information received from or about the victim without the consent of the victim. And that doesn't mean that there aren't exceptions, but this is a very strong privilege, and it was further bolstered by a few cases in the last few years, notably in Ray Hope, um, really set the standard that this privilege is going to be really hard to overcome for someone who um, information from you if you are a statutory sexual assault counselor. When it comes to the domestic violence advocate privilege, that's going to apply to an employee or supervised volunteer from a community-based battered women's shelter and domestic abuse program eligible to receive domestic violence program grants that provides information, advocacy, crisis intervention, emergency shelter, or support to victims of domestic abuse and who is not employed or under the supervision of law enforcement, a city, county, or state. And I broke that definition out a little bit just to show the contrast between this one and the sexual assault counselor definition, in that this one is is a bit more straightforward. But again, if there's any question or doubt, you can always talk to an attorney or reach out to Standpoint, just to be sure where you fall within this scheme. And the statute says they may not be compelled to disclose any opinion or information received from or about the victim without the consent of the victim unless ordered by the court. And that's highlighted there because while there are exceptions to any form of privilege, for the most part, this one is pretty broad. Unless ordered by the court basically means a court order. And I want to say that is not a subpoena, and we'll talk about subpoenas later on. But a court order could basically be, any order signed by a judge. Um, Here are the general exceptions for sexual assault counselors when it comes to neglect or termination of parental rights investigations or proceedings. You are going to be required to provide information for domestic violence advocates. That's going to be the court order. And again, you see how broad that is compared to the sexual assault counselor, which is going to be in very narrow circumstances. And then for both, you're going to have your mandated reporting obligations if you are a mandated reporter. And if you have any questions on that, you can, speak to an attorney familiar with these rules, and you can also call Standpoint. We're not going to talk about mandated reporting here because it's such a large topic, but generally that's going to be, you're going to be required to report maltreatment of a child or abuse of a vulnerable adult. And then presence of a third party is also going to break privilege. And that goes back to what I was saying about um, privilege is sort of this recognition of the importance of um, privacy and confidentiality within a relationship between the professional and the client. So if there is a third party presence, that sort of goes against the idea behind privilege, which is that it's really just the client and the professional providing services that this applies to. So a third party is going to break presence, even if it's a parent, if it's um, a support person, whoever it is. they are going to break that privilege. And so you do want to talk to your clients about that so they can make informed decisions about whether or not they do want that third party there. And breaking privilege just means the privilege does not apply to the information you received in that conversation. So you can be compelled to give that information regardless of whether any other exception applies. And then, of course, client waiver, because at the end of the day, it's going to be the client's decision to share whatever information they deem appropriate to share. When it comes to sharing information, there are some things you're going to want to keep in mind first and foremost. Um, some considerations are going to be, anytime you're disclosing information outside of that client professional relationship, you're going to want to think about what you're revealing and why you're revealing it, and whether it's a breach of your confidentiality obligations. Um, we know that confirming use of services is revealing information. In talking to coworkers, you could be in a situation where you're dealing with a victim survivor and you are not a mandated reporter, but your coworker is, and you share information you receive from your client with your coworker, and now your coworker has to make that mandated report because they have received credible information um, about something that's reportable. So you're just going to want to be thoughtful when you're speaking even to your coworkers about what obligations you have versus what obligations they have, and how it could put you in a situation to reveal information that the victim survivor does not want to be revealed. And when it comes to just generally speaking in public, you always want to be careful. It's a small world. And depending on your community, again, what seems like benign information could be enough to identify someone and put you in a position to violate your confidentiality obligations. And again, here, the can always choose to release whatever information they see fit. Um, sometimes as professionals, a client wants to release information and we have reservations or concerns or questions. And those are things that you should discuss with the client if they seem open to hearing about them. It's a part of them making an informed decision. But at the end of the day, regardless of any reservations, that decision is going to come down to whatever the client wants to do. So when can you share information? Generally, that's going to be when you have a signed release. And there are other situations we'll talk about later, but the client can choose to share information. And when they do, you want to have them sign a release of information. And that's going to be written. It's going to be time limited. So, for example, if you need a release to make a quick phone call, that release probably shouldn't be for an entire week. If you think the phone call might take you 20, 30 minutes, you should be specific in the release about how much time you need. And of course, things come up, you're busy, so, maybe say, okay, it's a 30-minute call. I'm going to give myself an hour and a half to make this call. But you do want to make sure that that time limit is reasonable for the circumstances of the release. Um, and that feeds into our next bullet point about being specific about the circumstances and the client's needs when you're putting together the release of information. And that's important because that's going to be helpful if there's ever a situation where you have an active release on file and you receive a subpoena or some other, or someone wants to get information about the client from you, you're going to be able to point to the specific circumstances that you've written down in the signed release as a reason that you can't just give them that information. And we'll talk a little bit more about that interaction later on. Um, when it comes to clients needing to consent to releases to receive service, that's not something that you can do. The client has to always have the choice to refuse. They're going to be able to also withdraw their consent at any time orally, but whatever it is, text, they're always going to be able to withdraw their consent. And it's helpful if you can talk them through potential consequences of consenting to a release of information. And all of this should be in a policy that your program has on release of information that the client can read before they sign to understand what the release should look like and some of the things we talked about here, that it should be time limited specific. And that's also going to help. It's also just going to help with talking your client through what that release is for and any reservations or concerns you may have. Sort of having a policy and talking about the consequences, the potential consequences can be helpful there. So, what are some potential consequences? The big one is going to be the information is going to go to the defense. The abuser can get a hold of it. Uh, it might be introduced as evidence in court. Staff may have to testify depending on the situation, and it may be a violation of the victim survivor's privacy because, as we said before, the default classification of data is public and accessible to everyone in Minnesota, and court proceedings are public, and that information is considered public and accessible to anyone generally. Um, there are some certain circumstances where information can be kept private or confidential, but that may or may not apply in the specific situation. So it is good to talk to them about the fact that this information may come out in open court. When can you share without a release? So you can generally share non-personally identifying aggregate data, statistics, although you do want to again look at your funding source and any obligations that they have any obligations that they have around stats because they may not require consent, but they may require some form of acknowledgement to be provided to clients. So you just want to double check that you don't have an obligation there. And then you might be required to share information without a release. If it's a mandated reporting situation, if there's an emergency, if someone is, physically unable to consent, they are unconscious, whatever it is, then you're going to want to get them help. Um, and then a court mandate, and again, that's a court order, not a subpoena. Now we're going to talk a bit about subpoenas. And a subpoena is a document, and in Minnesota, it's going to be signed by a court administrator or an attorney. And it's basically saying you need to come to court, you need to come to a deposition, you need to testify, you need to provide certain documents or records. And you want to remember that these are not court orders. A judge may not even know that a subpoena has been issued in a case they're overseeing. If your program receives a subpoena, we're going to talk about a few helpful practices later on. But if your program receives a subpoena, you do want to generally consult with an attorney. You can call Standpoint um, to talk through whether or not the subpoena was properly served, among other things. Uh, if if you receive a subpoena and you speak to your client and they do want to share whatever information the subpoena is requesting, then you go through the process we just spoke about with the release of information. You make sure it's time limited, it's specific, um, and Then if they want to share, then you release the information. If they don't want to share, then what you're going to want to do is retain an attorney and challenge the subpoena in court. Your attorney is going to argue that the potential negative impacts on your program, your client, your staff outweigh any potential need the party seeking the records or information may have. And uh, once the judge hears the arguments and makes a decision, they may find that the subpoena can, they might quash the subpoena. And quash, that just means basically deny the subpoena, make it no longer relevant, and, legally say you don't have to comply with that request. And if they quash the subpoena, then that's great. That's the end of it. But the court may also come back and say, we've done this balancing test and we think the information needs to be released. And at that point, maybe there are some further arguments you can make. Um, and, you can always call Standpoint and we'll work with you. We'll work with your attorney and provide the resources we have to try to mitigate that as much as we can. But you may have to release information. And at that point, you just want to make sure you are releasing the information that's been specifically requested. You don't want to release any more than you have to. Why are they a problem? Well, they force you to violate the laws we just spoke about that impose obligations on you, on your program, on your staff to keep certain information confidential or private. If you have a contract with requirements, such as a contract with the state that you receive funding through, you're going to be breaching that contract because it's also going to have requirements. It goes against general public policy about privacy and the right to choose to share information. And your own program should have its own sort of confidentiality policy. And it's going to force you to violate that as well. And it's going to open the door for hearsay, which is a legal rule of evidence about when information someone else said can and cannot be introduced in court as evidence. And of course, the real big one is that it deters victim survivors from seeking help. It deters um, our clients from accepting our help. Um, in Massachusetts, there was a study that found that there was a 20% decrease in reporting sexual assaults to the police out of fear of being forced to have your information revealed. So they are a problem. When can subpoenas be issued? So subpoenas for testimony can be issued regardless of if it's a civil or a criminal case. When it comes to subpoenas for confidential or privileged victim records, um, those can be issued in civil cases, and I've just listed a few matters there that fall into the civil bucket. And as of last July, they cannot be issued for confidential or privileged victim records in criminal cases. So this is one of those circumstances that highlight why it's important to know exactly what information is potentially protected by law, either federal or state law, so you can understand if it falls into this confidential or privileged bucket. And as we said, those definitions are not necessarily straightforward. So you do want to try to take a look at them and, or, call us and, I can talk you through um, what definitions are going to apply to your situation depending on your program, your staff, your role, um, because it's going to help you understand what's confidential and what's privileged when these situations come up. And just so you know, if there is a request for confidential or privileged documents in a criminal case, what they're going to do is they're going to file a motion in court and they're going to notify your program that they want those records. And the victim survivor is also going to be notified, and you're going to have an opportunity along with the victim survivor to go to court and to explain those arguments we talked about before about the negative impact of releasing the records versus any potential need the other side may have for them um, to um, to hopefully convince the judge that the records shouldn't be released. When can a subpoena not be quashed? That's going to be when a release of information is signed. So that is really one of the biggest reasons to ensure that your releases of information are going to be time limited and that they're going to be specific. Because if you have a general release that just says you can release information to whomever you need to release information to, and it's, you know, let's say it's set for a year and you have a client you haven't seen or spoken to and have no way to contact, and it's been 6 months and someone shows up with a subpoena, and this is, a civil case, you're not going to be able to fight that subpoena. You're going to have to provide those records. So ensuring that your releases are properly put together are going to be a good protection for you, for your client, for when those situations come up. Subpoenas are also not going to be able to be quashed when someone is a material witness. So if you actually witness the act, if you write a supporting affidavit, or if you're part of the chain of custody for a piece of evidence that's going to be used in the case, then you're not going to be able to get out of having to go testify. Things you can do to try to mitigate the impact of subpoenas are going to be develop policies. And some of that is going to be your record keeping policies. And Raylene's going to speak to you in depth later on. But some things you can do are designate someone to be in charge of your records, have a clear confidentiality policy, have a record keeping policy that's clear, and a document destruction policy. Um, and that's also going to be important because you don't want to be in a situation where you could be accused of potentially destroying documents in anticipation of receiving a subpoena, or just having documents on hand for years and years that you don't need to have on hand. Um, and then you're going to want a specific subpoena policy, and you're going to want to train your staff, new staff, um, train your staff regularly on these policies and provide copies to your clients. Specific subpoena policy should make it clear that no one should accept a subpoena for someone else. If a subpoena comes to your program for a client, you do not want to confirm or deny that you're there. And you can inform a direct supervisor or the person that is responsible for handling subpoenas at your organization. And again, you're going to want to talk to an attorney and talk to Standpoint, because there is some nuance there in terms of was it served properly and how that affects whether or not you have to comply. So what do you want to remember? Tell your supervisor, tell the person designated to handle subpoenas, and speak to an attorney. And then again, you don't want to destroy documents in anticipation of receiving a subpoena or a warrant. That is not legal, and that will be a whole separate problem on its own.
And then Tori, if I can just jump in real quick, I'll just share that as a new advocate, I think the fear of every higher power was instilled in me of subpoenas. I don't know if anyone else is in that same boat, but just it's really important, like Tori said, to know what the policy is on who can receive subpoenas and what that looks like. And absolutely, this is where you're going to involve your supervisor or the on-call person or whoever it might be. But definitely make sure you're not accepting a subpoena that doesn't have your name on it and know your policy because that's really going to be helpful. Because I don't know about the rest of you, but I was terrified to accept a subpoena on accident. I don't know why, but just be really, really careful about that and just know the policy, review it every now and again, and just be up to date on that.
Absolutely. And now we're going to talk a little bit about warrants because this may come up a bit more often in the current climate. And receiving a warrant, Raylene was just talking about um, being afraid of receiving subpoenas. I'm sure that dealing with warrants is something that also generates a lot of anxiety because it is a stressful situation for everyone involved. And there are a few things that you can try to do ahead of time to try to mitigate that. For example, trying to establish a relationship with your local law enforcement. You can try to get an understanding of their policies and practices around serving warrants. You can tell them your policy and practices regarding confidentiality so they understand your obligations, your legal obligations. If they use body cams, you can get a body cam policy from them. You can try to ask them to turn off their body cams if they ever do need to serve a warrant on your program. And those are all things that sort of come from trying to just reach out and establish a relationship with them. So, what are warrants? Generally, you're going to see either a search warrant or an arrest warrant. And the search warrant authorizes law enforcement to search a specific location for a person or physical items that may be used as evidence in a legal proceeding. An arrest warrant authorizes law enforcement to arrest a specific person. Um, and they're both going to be written court orders signed by a judge. And I do want to emphasize that because there are situations where someone may try to present something as a warrant, but it's not signed by a judge and it doesn't carry the same authority as a warrant that is signed by a judge. And we'll talk about that in detail a little later on. So, what can you do generally when officers show up at your door with a warrant? Well, you want to ask them to wait outside, ask them to wait until you call your supervisor or the person designated to handle these issues. You want to ask to see the warrant. And when you're looking at the warrant, you want to make sure you're confirming what they're looking for, who they're looking for, where they can search. You want to get the officer's information. You want to look at their badge, confirm what agency they're from, get their card, their name, write down their information. And if it's possible, you want to erase any open listings of residents' names, direct residents to their rooms, and ask them to stay there until they're told otherwise. And of course, you don't want to tell the residents why or who the officers are looking for. For search warrants specifically, when you're looking at that warrant, you're going to want to look at the date it was signed. Search warrants that are not served within 10 days of when they're issued are void. They're no longer valid. Um, so you don't have to comply with that. Search warrants can only be served between 7 a.m. and 8 p.m. unless the warrant says otherwise. So you want to be looking for that, checking what time it is. If they're looking for a person, you want to request the opportunity to surrender that person, or if they're looking for an item, to surrender that item. If it's for a person, you're going to want to try to speak to that person and ask them to cooperate rather than expose the entire program to whatever may ensue if they don't cooperate. Um, and if they're doing a search, you want to request to accompany them, to show them the specific room that they're looking for. And if the person shares a room, to show them where that person's things are, to try to mitigate the effect on the entire program as much as possible. When it comes to an arrest warrant, you're looking at that warrant for the identity of the person named in the warrant. Um, you want to, again, verify that it is signed by a judge. And I'm emphasizing that here because ICE agents may present themselves as your local law enforcement, or just, wear clothing that says police, and claim they have an arrest warrant. So you want to make sure that's signed by a judge. And again, collect the officer's information, all of those things we talked about generally, and verify what agency they're from. You're going to want to ask the officers if they saw the person in the arrest warrant entering the building. And if they did, then you're going to, again, request the opportunity to surrender the individuals, try to speak to them privately, ask them to cooperate, and let the officers execute the warrant. If they did not see the person come in, then the officers can't enter and they can be told, they basically cannot confirm or deny standard line, and you can offer to post a note in a public place. When it comes to ICE, they may try to present themselves as law enforcement. They may wear clothing that says police, or have, stripes on their hats, whatever it may be that says police. So it's important to look at that warrant and make sure that it is a judicial warrant. And a warrant that comes from a court is basically going to look like a court document. ICE oftentimes is going to have what's called an ICE administrative warrant. And that's generally a removal warrant. And it's going to basically look like, um, any sort of typical government form, um, versus something that looks like a court order. So when you're looking at the warrant, you're looking for clues that this is a court order signed by a judge, as well as, um, for the name of the person they're looking for. Again, you're not going to want to confirm or deny that the person is there. Um, you're going to want to, if it's an ICE removal warrant, you're gonna want to confirm again, it's not signed by a judge. A uh, it's not a warrant that came from a court of law, and then you can deny them entry. They do not have authority to enter and search a private place such as a home or a shelter, um, just on an ICE removal warrant. They're going to need a warrant that's signed by a judge. And of course, you're going to want to notify the individual that's listed in that warrant that, ICE is looking for them so they can take whatever steps they need to try to protect themselves. What do you want to remember generally? You want them to wait outside until you contact your supervisor or the designated person for this. Try to figure out what agency they're from, ask to see their badge, get their card, their name, information. And then you're going to look at the warrant and you're going to want to look at it specifically for those things we talked about, for each particular type of warrant. And at this point, I will turn things over to Raylene.
Fabulous. Thanks, Tori. So I know confidentiality, privacy, all of these things can be a lot to think about because we're trying to balance many different things. We want to protect the folks that we're working with and the folks that we're serving. We also have to protect our agency, and kind of the rights of victims and survivors as a whole. And then we also have to follow the law. So, and there's lots of different laws as we learned today. So there's lots of things to kind of keep in mind when balancing all of these different issues, which is why policies are super helpful. So we'll jump a little bit into what those policies could look like and some record keeping. And if we can go to the next slide, Tori, that would be super. Beautiful. Okay. So when we're thinking about the different kind of records that we are keeping, again, we're doing a lot of balancing tests here and trying to figure out what is the right path. So, as Tori mentioned, a lot of different funding sources require different kinds of records to be kept. Anything from demographic information to there was one grant at one point that we were looking at that tracked whether or not people were smoking cigarettes. So, lots of different things might need tracking. And so, just be really, really conscious of what that looks like. Talking to supervisors and helping advocates design forms that kind of reflect all of these different funding requirements that we have. So that's one reason why we keep some records. The other reason that we're thinking about, of course, is the needs of the victims and survivors that we're working with. What kind of information do we need to help them keep so that they can move forward, and what kind of things might be helpful and beneficial for them, both in the immediate situation in terms of their safety planning and things like that, and longer term if they're involved in court proceedings or things like that that they might need in the future. And then we are also thinking about statistics and program evaluation. Statistics are kind of related to funding requirements in that we often have to report our statistics back to our funders, but it also tells us the story about the work that we're doing as well. Tells us who we're serving, who we're not serving, and can really help us identify some of those gaps or room for improvement or new opportunities for us. So, for example, we might all of a sudden see that we're serving more people over the age of 65. So maybe we're thinking about elder support and adding that to our core services, something along those lines. That information can be really helpful. Same thing with program evaluation as well. If we are noticing that part of our program is underutilized or overutilized, that can really help us figure out staffing issues or where we need to direct staff attention to, where we can promote our work differently, and how we can make improvements to the work that we're already doing. And then finally, we are also evaluating protecting the program itself. So what kind of documentation do we have to keep in terms of liability, following all of these laws that we've been talking about, and all kinds of funding requirements as well, because we need the program to continue to be funded. So we have to kind of balance all of these different needs when determining what kind of information we are keeping and what kind of records we're saving. And I think we can go to the next slide. Beautiful. So, in thinking about record keeping, there's lots of different ways that we do this as advocates. There's lots of different formats. Back in the day, was it thinking about like Excel spreadsheets, handwritten notebooks? There's lots of different ways that we do it. But we really want to think through what are we keeping? What is that information? So there's this nice little acronym that Raina had come up with, PRAF. So we're thinking about the purpose, the risk, the assessment, and the form. So first and foremost, we always like to say that less documentation is more. So if we keep fewer information in the files, and whether it's folders or digital or whatever that might be, that can be a protective measure for the folks that we're serving. So kind of keep that in the back of your mind. And then when you are writing any kind of record, whether it's an intake form or other kinds of documentation that you kind of normally keep as a part of your program, ask yourself, why are you writing this down? What is the purpose of this exact sentence, or what is the purpose of sharing? We might be talking about someone's mental health or chemical health, and what is the purpose of me documenting that piece exactly? Perhaps it's to help document services that you are providing, making referrals to other programs. Um, But if that record were to be subpoenaed later on, that could draw attention to the fact that this particular person maybe had some struggles or concerns around chemical health or mental health. So again, just be really, really clear on what the purpose is in writing anything down or typing it or whatever you might be doing, whatever the form is. And then we also have to think about the risk. When we think about the risk, it's of what is the risk to the victim survivor if that information is disclosed, just like we kind of talked about, and what is the risk to the program? And then alternatively, on the flip side, we also have to ask ourselves, what is the risk of not keeping that information? So playing a little bit of a devil's advocate. So if I don't write this down, what do we lose here, or what kind of safety risk could we be posing to the victim survivor? And then assessment is asking ourselves, will we want to keep that data or that information, even if we decide there is a risk to it? So, do we still want to keep that information if there is a risk? Because sometimes we have to. Sometimes we have to keep information, again, as we're balancing all of these different needs. And then finally, if we think about the form, we ask ourselves, is there a way to record this information without including any identifying information? Or perhaps can I share this with staff in a post-it note rather than the client's actual file? I know there's lots of different ways that in shelter and other kinds of programs we're communicating, whether it's a daily log, kind of progress notes or client notes, or sometimes we're just doing shift change and there's a way to kind of share information so that the next team or the oncoming staff are prepared and ready to take on the shift. Have all the information that they need, but things don't necessarily need to be documented in written form so that it doesn't cause any future harm to any victims and survivors. So those are some things to kind of think about when it comes to record keeping. Of course, there's lots of conversation to be had in that and how you do it and what is the kind of way that your program is going to tackle that. But these are some questions to be asking of yourself as you're taking your notes and doing your work, and of your program as you are kind of designing forms and databases and all of these sorts of things. And then we think a lot about what records do we keep. So, like we talked about, there's lots of different ways that we are collecting data. As we take a phone call, how are we documenting that call? Is there something that we're keeping on paper? Is there something that we have to enter into a database? Do we count statistics? What does that look like? A daily log, often a way that advocates communicate just to kind of keep track of what was going on in the shelter during the day, what kinds of things need to be passed on to the next shift, or just kind of communicated about, and what does that look like. In every place I've been in, every client has their own file, whether it's on paper or on the computer or both, to be honest. We use lots of paper in this work. So what kind of information are we keeping in there? Is it different for each client? Do we keep the same information for each client? What does that look like? And then, of course, there's lots of other ways that we're communicating, whether that's on like apps that we're using to talk with each other about shifts and things like that, or whether it's email, lots of different ways that we are keeping records and documenting information. So there's all kinds of ways that different programs do that. And you just want to make sure that you're asking yourself that craft question, that record keeping question for each of those different forms. And then, as we think about what are we writing down, and this is going to be again different for every program based on what your funding sources are and what risk you've decided you're comfortable with, and what the needs of each kind of program are. So most of the time, we as advocates are keeping track of services provided. Are we providing information and referrals? Are we providing transportation? Are we providing in-kind services, food shelf, legal advocacy support? Did we write a protective order? Those are kinds of things that most of us have to keep track of. And again, that's about balancing all of those different things in terms of funders, in terms of program accountability and program evaluation, these sorts of things. So we need to know numbers. We like numbers. The other things to think about in terms of wondering whether you should write something down is what would you feel comfortable sharing with the client? So let's say you had a long conversation with a victim survivor and you talked about a lot of really personal things. You talked about their history of violence that they've experienced and had a really, really good, powerful conversation. What of that conversation would you keep in their file? I think a lot of times, those conversations, we don't have to necessarily be documenting everything. Because if I had a conversation with an advocate, poured my heart out, and then had to read back or found out what that advocate wrote about me, I might be really uncomfortable. So if we can, as advocates, if we can really reflect, have our notes reflect how we would talk about that information with the client, that can be really helpful. Because clients have the right to see their file and their paperwork and everything that we're kind of keeping about them. So always know that that is something that could happen, whether it's the client requesting to see that documentation, or if it gets to the point where things are being subpoenaed and things like that. We really want to make sure we're just being really mindful about that. Then I do see a question in the chat about a database. That is a great question. Databases, there's so much information out there. I don't have a particular one, and every program has different needs, so I cannot be specific for you, unfortunately. That is a huge, a huge conversation. I'm happy to chat about it via email if you'd like, but keep that in mind. Let's see. All right. So if we, and then lots of other things. Sorry, lots of other things can be written down in those files. I think about if there is an accident that happens in shelter and there's an incident report where, someone fell and bumped their head. Oftentimes we're keeping stuff like that because it's about program liability. Perhaps we are keeping protective orders and other kind of court orders so that clients have that accessible to them going forward and you know what's going on. I do housing work, so I'm probably going to keep a lease break document in that file as well. Again, we just want to make sure that whatever we're writing down is for the benefit of the victim survivor, balancing out program needs and program liability. So just keep all that in mind as you're documenting. And then there are a few things that we want to make sure that we are, or we caution you against writing down. So first and foremost, verbatim statements. And I think there have been times where I've been told to write down verbatim statements as an advocate, but that can pose some risk in terms of subpoenas and things going forward. So definitely be mindful about that. Any kind of comments about drugs or alcohol. Again, if the client or the court were to read comments like that, what kind of light would that paint the victim survivor in, and what kind of risk could that pose to them going forward? We in shelter see a lot of different parenting styles, so being really mindful about how we talk about parenting in our notes, if at all, can be really, really impactful and really important. Great conversations to have, don't necessarily need to write that one down. Again, it could pose risk to that victim survivor going forward, especially if they're going through family court or if there's child protection involvement, things like that. It's not about hiding information. It's about being mindful about what we're doing and how we're sharing that. And then we as advocates, of course, are not to be diagnosing people. So we don't want to be speculating about that in any kind of our notes or documentation. So keep all of that information outside of the file. Again, we also do not make legal conclusions or provide legal advice. So that's not something that we want to keep in the file or have written down in any way. And then another one that's really easy to kind of fall into is including the names of other clients in someone's file. Especially when, people used to share rooms a lot of the times. They don't at every program now, but or there might be an incident in a shelter where two clients are involved, perhaps. So we really want to be mindful of making sure that we are not sharing other clients' names in someone else's file. So you can say, just be really mindful of that because we don't want to break confidentiality. And then we don't necessarily need to be sharing people's comings and goings from the shelter in their file. Yes, we absolutely have to keep track of who's in a building for fire safety reasons and other kinds of things like that. And tracking who's here on an overnight, things like that is super important. Most of the places that I've been at have like a sign in and sign out sheet or something along those lines. And that's super helpful for staff. As an overnight person, I need to know who's in the building in case there's a fire, for example. But we don't have to keep that information in their file necessarily, and we might not even need to keep it for that long. So just asking ourselves again, what's the point of me keeping this documentation? Do I need our sign-in sheets for months on end? Or after the night is over, can I shred that? Can we move on? And then anything else? I don't know, Tori, if you thought of anything else that we might not want to keep in the file or anyone here with us today. But these are some of the ones that I was thinking about. Perfect. All right. So that's a little bit of not of what not to do. Some things that we do want to keep in the file would be our intake forms. Every program's intake form is different, so keeping that in the file, and again, file being either paper, digital, or both, whatever that might look like. Oftentimes we have an exit form when someone is done receiving services from us or exiting the program, whatever that might be. And that can be information that we use to improve our programs, provide new opportunities, or just have some documentation about an exit that happened. Tori talked a lot about releases of information and keeping those in the file. That's a really good place to save that information. If someone is staying in shelter, having an acknowledgement of the house rules or the policies and procedures, or whatever words you might use for that, is really important to keep in the file. Any kind of waivers that have been signed throughout their stay with you, and other kinds of permission forms, medical authorization forms, liability forms, things that are going to kind of help make their stay at the shelter safer, is kind of what we're thinking about there. Sometimes people have a form saying, if you are experiencing medical distress, do you authorize us to call 911? Something like that. Those kinds of things are important to keep in the file because it's about safety. If a mandated report has happened, that is definitely something that you would want to keep in the file. And then I didn't put it on the slide, but protective orders can be excellent to keep in there as well. And there might be lots of other things that come up during someone's stay, especially if they've been in shelter for a while, information about kiddo schools, things like that. Again, it's just asking yourself, what is important to keep and why are we keeping it and for how long? So those are some of the things that are often in our files.
And just going back quickly
Yeah,
to not to keep in the file, you want to make sure you're not keeping the client's personal effects, personal notes, diaries, things like that, because those things are not going to be protected if they're in your file, and they're going to be able to get into the hands of the defense, the abuser, if if they're subpoenaed and they come up in court. So you want to make sure you're keeping those out of the file.
thank you, Tori. And then additionally, other things to maybe not keep in the file would be potentially a safety plan. If we think about it, if we have a written safety plan, one, I'm not going to be able to find it when I need safety anyway. So I really encourage folks to do a lot of conversation about that safety plan. It can be useful to have certain things written down for the victim survivor, as long as it's safe for them to keep it. But if we keep it in the file and that file does get subpoenaed, then that is information that an unsafe person could have. And so we want to make sure that we're being really cautious about that. And then, as Tori said, any of the client's own written materials, super important. And same goes for evidence as well, and for any kind of court proceeding. So being really mindful about not keeping those in the client file. Anything else that we're thinking about? Or any questions about other things that we might not want to keep in the file? I don't think so. Beautiful. So with that, I just had a short bit at the end there. Do we have any questions? I know we covered a lot of different things around confidentiality, releases, subpoenas, warrants. These are all really kind of important things for us to consider, particularly now as we're doing this work. So if any other questions come up at all. And we can also stop the recording to take some time as well. Maybe I'll do that. So thank you all for attending the webinar. I'm going to stop the recording and then we'll have some time for questions.